to protect assets. And what that is that's an asset protection will. I was listening to somebody on TikTok, and what he said is, never have a will, never go through probate, never do this. And it really struck me. How can a lawyer ever say always or never when it comes to the particular type of planning tool that's right for that client? Let me give you a little bit of background. So in Washington, as I mentioned, probates are really simple here. Do they cost money? Of course they cost money. Anytime you're working with a lawyer, it costs money. Unless you're getting free services from a pro bono program. But if you're dealing with an attorney in a law office, that does cost money, period. Is it worth the benefit? That's the question you need to ask. So in Washington, if we want to protect assets for a surviving spouse against long-term care costs, the only way we can do that is if we use a will with an asset protection trust. That means that will must be probated when the first spouse dies. And then all of the assets of the deceased spouse will fund this asset protection trust. All the money in that trust will not be counted by Medicaid in the state of Washington if the surviving spouse needs long-term care. So let me give you an example. Let's say a couple has $1 million. They have a house worth $500,000. They have $500,000 in other investable assets. One of the spouses has Alzheimer's, and they're what we call the ill spouse. They won't be able to live at home if the well spouse isn't there. And the well spouse has a heart attack and the well spouse dies. As part of doing their estate planning, we knew that we wanted to protect assets for the spouse with Alzheimer's. So we did a separate property agreement. We put 100% of the assets into the name of the otherwise healthy spouse, who then later on had a heart attack. So $1 million is what is the deceased spouse's share. $1 million is going to funnel through that person's will into the asset protection supplemental needs trust for the surviving spouse. Surviving spouse is going to have to move to a care facility. They can't live at home anymore. There is the house or the proceeds from the sale of the house in that trust. There's another $500,000. There's $1 million in this trust. And you know what? Medicaid says they look at it and they say, oh, we don't count any of those assets as belonging to the surviving spouse, the one who needs care. That's Washington's rule. That's why it's so critically important. If you are concerned about protecting assets for your spouse when you're gone against long-term care costs, a will is absolutely necessary. A will means there will be a probate. Yes, there's going to be costs associated with the probate. Let's say that probate costs $5,000, $10,000. Is it worth it to protect $1 million against required spend down? That's why in the state of Washington, a will with an asset protection trust is our best planning tool. If you are concerned about making sure you don't leave your spouse impoverished because of long-term care costs, then it's a will with an asset protection trust that I would recommend. If you've heard through other attorneys, through other videos, avoid probate at all costs, you're going to have to say, what are they talking about? At all costs? You mean you don't want to spend $5,000 to $10,000 for a probate to protect $1 million? That makes no sense. If you ever hear somebody say you absolutely must avoid probate, how? You do it through a revocable living trust. You should have a revocable living trust. You've got to ask more questions. So a revocable living trust, the whole idea with it is so that you don't have to go through a probate. So if you're not going through a probate, you have a revocable living trust. That's your setup. So with a revocable living trust, the whole idea is so that you can avoid a probate. All right, you live in Washington. You're that same couple that I just described. You know, one has Alzheimer's, one seems to be healthy. What happens when the one who has a heart attack dies? Well, guess what? All the assets belong to the surviving spouse. And so what if in their revocable living trust, they set up a marital trust or some other kind of trust to hold the deceased spouse's share? Maybe they even tried to set it up as an asset protection trust. State of Washington will not honor that as an asset protection supplemental needs trust. That surviving spouse who now has $1 million and has Alzheimer's and needs care, all of that money is theirs. The state says zero, none of it is protected. All of it is going to have to be spent down before that person is eligible. So rather than protecting the entirety of this couple's estate by using a will-based estate planning platform, they were told avoid probate. So they followed that guidance and they set up a revocable living trust. Rather than protecting $1 million, they protected zero. It all needs to be spent down on long-term care costs. So when somebody tells you that you must avoid probate, you must have a revocable living trust, I would suggest that you ask questions. Well, why is that? Well, because you want to avoid probate. Okay, well, what are you trying to accomplish with your estate plan? You see, estate planning isn't about documents or you must have this or you must have that. It's about having an understanding of what your goals are. What are you trying to accomplish? Are you trying to protect assets against long-term care costs for your spouse? If so, I would likely recommend the will with the asset protection trust. On the other hand, if you have long-term care insurance or you have millions of dollars of assets, and let's say you have property in Oregon, Idaho, California, and Washington, I likely would recommend a revocable living trust route is the best way for you to go. And rather than focusing on, the long-term care cost issue, we're then focusing on avoiding estate tax in Oregon and in Washington. Washington, our estate tax is at $2.193 million. You can use a revocable living trust, or you can use a will platform to protect against unnecessary estate taxes imposed by any of the states that have an estate tax. Idaho does not. So protecting against estate taxes might be the goal of your estate plan. And it might be that you have property in multiple states. So a revocable living trust is the smart way to go. You don't want a probate in California. You don't want a probate in all of those jurisdictions. So yes, a revocable living trust is the right way to go. I can't answer the question, what is the right way for you in terms of what your estate plan is, but what I can tell you is that a good estate planning and elder law attorney is going to sit down with you, find out what your situation is, what your goals are, what are the threats to your estate plan. Is it long-term care costs, or is it paying unnecessary estate taxes? So all of those things are important to talk to your attorney about, the estate planning and the elder law attorney. If you have any concerns about long-term care costs, I would recommend that you are working not just with an estate planning lawyer, but with one that has elder law and Medicaid expertise, because that is a really focused area of practice that many people who do estate planning and do it very well wouldn't understand why certain provisions need to be included in a durable power of attorney, or why the will should be set up in a particular way, or why a revocable living trust should be avoided. Many estate planning practitioners in the state of Washington would not know what I just told you, which is that a revocable living trust will not protect assets for a surviving spouse against long-term care costs. So these are, they're worthy of having a discussion with your attorney. A couple of other threats that I haven't mentioned that these a will or a revocable living trust can protect you and your beneficiaries from is the unintentional disinheritance and creditors. Both wills and both revocable living trusts have the ability to make sure that creditors of your beneficiaries cannot get more than what they're entitled to, or we can actually defeat creditors' claims if they don't follow the appropriate mechanism that the law sets up to collect. So we can avoid certain creditors and having to pay them. Unintentional disinheritance, what that is when somebody is, let's say it's a couple, and they've been married 50 years and they've got 2 kids and they both agree, of course, when we're both gone, we want our kids to get whatever, whatever's left. And then what happens is one dies, and then sometimes this happens at age 70 or 80, the person who's a surviving spouse remarries and they fall in love and they get in a new estate plan. And that new estate plan might be set up just like the couple's old estate plan was, which is everything goes to the surviving spouse. Well, if that's the situation, then the surviving spouse, let's say it's the person who's the new spouse, they're the survivor. What ends up happening is that the children from that first marriage, they end up getting nothing. That happens much more commonly with blended families. The way to avoid that is through setting up trusts for the surviving spouse so that they don't have the ability to redirect assets. That can be done through a will or through a revocable living trust. Again, as an estate planning lawyer, as elder law attorney, what we're thinking about are the what ifs. And so many times clients say, oh, I've never thought of that. Well, of course you haven't, and you shouldn't think about that. My job is to make sure I think about all these threats, all these things that might happen, so that your estate plan has all these protections in place so that you don't have to pay unnecessary estate taxes. We protect assets against long-term care costs. We make sure your beneficiaries get what you want them to get and not some new family. That we protect assets for your beneficiaries. Let's say one of your kids is on government benefits. We don't want to lose those. So we'll make sure their benefits go to an asset protection trust, just like the one that I described for the surviving spouse against long-term care costs. That kind of a trust is a discretionary trust. It's called a supplemental needs trust. What that means is that the government doesn't believe that those assets in there that are for the benefit of the person belong to the person, because they don't. And therefore, those assets don't interfere with government benefits. We can set up trusts for the beneficiaries to make sure that if there is a divorcing spouse of that beneficiary, they never get any of that money. It is protected against the divorcing spouse, against creditors, against any sort of threat that I can envision as an estate planning and elder law attorney. So there are very definite actions that can be taken to make sure that none of these possible threats will eat up your money, and either during your lifetime or once you are gone.